welcome everyone. I'm Brooklyn Law School Professor Cynthia Godsoe, and I'm really excited to welcome you to this event celebrating Professor Marsha Garrison's book, Tying the Knot. Professor Garrison is one of the foremost scholars in family law, combining a comparative perspective and theoretical insights with pragmatic recommendations to actually help families in the real world. And on a personal note, she's been a mentor and teacher to generations of lawyers and scholars, including me. I want to keep the welcome short because we have so much to discuss, but just a few notes. The event is being recorded. There will be a time for audience questions after the conversation between Professor Garrison and Professor Cherlin, who I'll introduce in a minute. And then when we open it up to audience questions, I will take questions from the Q&A box so people can put them in, and from the live people if they want to raise their hands. So some introductions. Marsha Garrison is the 1901 Distinguished Research Professor of Law at Brooklyn Law School. Her scholarship, published in a wide variety of books and law journals, focuses on public policy related to children, families, and reproductive technology. She's also a member of the American Law Institute and the advisory boards of the Cambridge Family Law Center, the Child and Family Law Quarterly, and the International Journal of Law, Policy, and the Family. I'm just keeping it short, but she has many, many, many accomplishments. Andrew Cherlin is the Benjamin H. Griswold III Professor Emeritus of Public Policy at Johns Hopkins University. His most recent books are Labor's Love Lost, The Rise and Fall of the Working Class Family in America, and The Marriage Go Round, The State of Marriage and the Family in America Today. He's a member of the American Academy of Political and Social Science, the American Academy of Arts and Sciences, and the National Academy of Sciences. And again, I'm shortening the bio from his very distinguished career. So to get us started, I wanted to ask Professor Garrison, could you tell us something about the central argument of Tying the Knot and why now? Why you wrote the book now?
Sure. Before I do that, I want to apologize first for the fact that I'm hoarse. There's a lot of pollen in New York now, and my voice is a little raspy. Second, I want to pause for a moment to first thank Brooklyn Law School for all of its support for my research over the years. Without that support, this book wouldn't have been possible. And I want to thank both Andy and Cynthia for participating in this event. Andy will be able to give us a really interdisciplinary perspective on the issues my book discusses. And his work, as many of you know, has been extraordinarily important in revealing details about family life that are crucial to family law scholars as we try to tie family law to the realities on the ground that families live. I also want to thank my colleague Cynthia, one of the busiest people I know, who has nonetheless taken time out of her extraordinarily busy work schedule to participate and lead this event. Thanks to both of you. So let me say a word about the book at this point. The metaphor tying the knot says a lot about why I wanted to write the book and why now. It provides a good visual symbol of what I view as important. When I wrote this book first, most trivially, I wanted to tie together different parts of family law that I had written about and unify them. Much more importantly, I wanted to tie together traditional private family law, dealing with the obligations between family members, with the often neglected public family law, regulating a range of benefits and burdens that today dwarf private law, both in their numbers and in their importance to the way families live their lives. That public family law has long been a stepchild of the family law canon. It's typically given short shrift or nothing at all in the traditional family law course, and it's often neglected in discourse about family law. But it's so important that we must integrate these two different areas if we're to truly serve the families that need a working family law. Finally, we are at this point, I think it's fair to say, in a situation in which families are in crisis. the care responsibilities that we expect families to perform have not declined, either in importance or in the time that they consume. You can make a strong case that they've expanded. The period in which children are economically dependent on parents is larger. The period in which older family members are vulnerable and need family care has also expanded. Add to that basic problem the fact that the family itself has shifted. Families are smaller, they're more geographically dispersed. Most adults, in some families, all adults, work outside the home in addition to providing care responsibilities. And today, separation of families is a key factor that drives family resources into separate households and divides its capacity to provide care. These are problems in all industrialized Western economies, but they are particularly acute in the United States. We know that there's a firm link between the way families lived and both inequality in incomes and social mobility. Crafting a family law that serves genuinely the needs of today's families is thus crucially important, both to the families and to the societies in which we live. And I hope this book will make a contribution to that effort.
Great, thanks. Andy, initial reactions?
So I'm a sociologist, and I've been studying how families are doing for decades now. And I remember a period in the early 1980s where we'd just gone through a huge increase in the divorce rate, following upon California's initial so-called no-fault divorce law in 1969. By the 1980s, the divorce rate had nearly doubled. I really wasn't sure what the legal implications are and what we should do, so I decided to ask my friends in family law. And it turned out they had no idea also. None of us had a clue about what to do in the early 1980s. But we have now made great progress, as Marsha's excellent book shows. Certainly in marriage and divorce, we have made great progress, and I think we know a lot about what to do, as you showed, although there are still issues which you talk about. There are new challenges, however, that we now face, such as cohabitation, which Marsha also examines. It's now the case that 40% of all the parental disruptions that children experience come from cohabiting unions. 40%. Only 60% of them are divorces, legal divorces. And the cohabitation percentages are going up and up. It may be in 5 or 10 years that a majority of all the disruptions that children face don't come from marriages, and they're therefore not found, cannot find a solution in marriage and divorce law. We may have figured out divorce, in other words, at just a time when fewer and fewer children are getting family disruption because of it. So that's another challenge that we need to face, and I'm looking forward to talking with you about it. I'm also looking forward to talking about public law. The title of the book is Family Life, Family Law, and Family Justice, Tying the Knot. So why is the subtitle Tying the Knot?
Well, it's first of all a long-standing metaphor in family law. We tie the knot when we unite individuals in family relationships, but we also need to tie the knots between public and private family law, and also between the realities of family life, which you've been investigating, and the rules that govern family status, family benefits, family taxation, the whole realm of family laws that affect how families live and their capacity to care for their members.
So perhaps naively, when I thought about the discipline of family law, I thought about it as about relatively circumscribed statutes about how one proceeds in the case of a marriage or a divorce, and voluminous case law in case law books such as yours. I haven't thought of it as including what I would call family policy. Yet the last third of your book, which we'll talk about, is all about larger issues such as childcare assistance, family leave, child allowances. So have I been overly narrow in my conception of what family law as a study is all about?
Well, the short answer is yes. But that narrow conception, as I mentioned, is also all too often true of family law. We too have not taken a broad enough view of family law. But it's this other law, which is law. It's contained in statutes. It's legally binding. It's enforceable. It produces cases. Is just as much law as the traditional law of marriage and divorce. And to provide a quick numerical example, at the time the United States Supreme Court decided the first of its decisions on same-sex marriage, the Windsor decision, dealing with the so-called Defense of Marriage Act, there were more than 1,000 federal statutes that dealt with marriage. None of those statutes form part of the corpus of traditional family law, but they're vitally important to the families whom they affect. The specific law at issue in Windsor was a provision of the federal estate and gift tax code, but it affected the capacity of one partner to transfer assets to the other in a major way.
Okay, so I stand corrected and maybe enlightened about the breadth of family law as a discipline. You talk about a number of principles emerging, like individual autonomy, which maybe had its start with the California no-fault divorce law and other changes of that ilk. And you talk about consistency, treating situations that are similar, treating them alike. Let's talk for a minute about marriage and divorce. So you certainly, as everyone today, almost everyone today does, rejects the old fault-based divorce, for sure. Interestingly, you also seem to try to minimize the role that judges have and the amount of adjudication that happens in favor of more administrative solutions. Tell me about some of those. The sociologists listening, at least, may not know things such as family relationship centers, which you mentioned as an alternative to divorce courts. What do they do? What's that all about?
Well, the Family Relationship Center was an Australian innovation, and its aim was to provide resources, particularly for parents with children, so as to reduce the likelihood that they would need intensive court adjudication, which is divisive and harmful to them and their children. Happily, when the Australians instituted this innovation, they included an assessment plan, and it showed that indeed it worked. People who made use of the family relationship centers were more likely to settle their disagreements. Those arrangements that they worked out themselves with help from the family relationship center were also more likely to survive and not require further courtroom adjudication. We know this from various projects in the United States as well, that arrangements people work out for themselves often have much greater durability and achieve higher user satisfaction, and thus better family relations if judges are not involved. Courts also really are not well equipped to deal with the kinds of problems that parents bring to those courts. The central task of a court dealing with a custody case, for example, is to come up with a plan that will govern how this family allocates residential care in the future. But courts are best at assessing what happened in the past. And it's a one-time proceeding. Once the proceeding is over, it stops. It's not helpful for people to have to return continually to a court. It's highly expensive. It requires legal assistance if they're going to really have a shot at getting themselves heard effectively. It just doesn't work in an era in which we have lots and lots of cases and very similar problems that could be dealt with rules and guidelines that could be used by couples themselves to resolve most of the disagreements that a court might otherwise have to spend time on and might also be less able to reach a uniform result with.
So this is a bit of a paradigm shift then from courts and adjudication to relationship centers staffed by counselors, to administrative procedures. Some people, and even a part of me says, well, that's going to work for adults, but are you going to be able to protect children's interests well enough if you go away from allowing judges to make decisions in individual cases.
Well, I'm not saying that you can eliminate judges. Certainly not. We're going to need them. But we don't need as much courtroom work as we now have. Some American states, notably California, have pioneered approaches that make use of administration. In California, if you want a divorce and you have assets worth a certain level and you don't have a child custody problem, then you can file papers. You don't need a lawyer. You can simply do it just on those papers and get your divorce. France recently instituted a similar system for all divorces. Lawyers needed to sign off in France. You can argue that that's not necessary in all cases. But if people can reach agreement themselves, why should they have to go to court? Now, one reason they do is because many of our current rules are extremely indeterminate. And that's not just true of custody law. It's true of spousal support, and it's true of property division. But if you had clear rules, as we do in child support, then people would be largely able to resolve most of their disagreements themselves. Those disagreements that persisted, many of them could be resolved by family relationship centers, leaving courts with the core, very difficult cases, a much smaller fraction than the total.
You know, in some sense, the persistence of judges determining what should be done comes from the old fault-based system. I mean, that's what we had until about 50 years ago. And there, you had to prove that someone was at fault, and you had to do that legally. Looking back now, it doesn't make much sense to do that if we've moved away from that. And clearly, you want to move away from that, reasonably so.
And that's exactly right. The no-fault divorce reform, as I chart in my book, was a partial reform. Whenever we reform the law, we tend to do so in fits and starts and incrementally. And some of the old persists along with the new. So when no-fault divorce was instituted, we kept the old adjudicative model, and we also kept judicial discretion, which we needed for fault, and we needed for all the fault-based remedies that went with it. With fault largely removed, we don't need it. And there's no reason to persist in using it. I think that's absolutely right.
I just wanted to jump in for a minute to say, first of all, that even in New York, we were the latest, 2010. So we've only even had the possibility of no fault for a relatively short time. But Marsha, you had talked about an Australian and a French example, and I know you conclude in your book that the U.S. is doing a particularly poor job of especially meeting children's needs, but families' needs. And in what ways do you think other countries are doing better? What can we learn from them? You know, expanding on some of the models you've already spoken about.
Well, the Family Relationship Center is one. We in the United States tend to be fairly insular in our approach to lots of issues. And certainly there is much that we can learn from other countries in the area of family law. Some other countries have done much more than we have with respect to developing clear rules and guidelines that families can use, and with moving family disputes out of courtrooms and into non-adjudicative settings where they get the kind of services that they need. Equally important, I would say more important, the United States is very far behind our peers when it comes to public law and its supports for families. As a result of that, children's poverty in the United States is higher than in any of our peer nations. And families here are more stressed than they are in other of our peer nations. If you look at a range of indicators of family functioning, the US is so far down the charts that it's laughable. And we pay the price, not only in higher levels of child poverty, but in all of the attendant costs that child poverty produces. A nonpartisan panel established by Congress to estimate the cost of child poverty and come up with some solutions. Recently, only a few years ago, indicated that those annual costs were more than $1 billion. Multiply by that, and we can learn a lot from peer nations in terms of how to better support families through public family law that provides the kind of financial, childcare, and educational supports that today's families need.
You know, many social scientists and family law scholars have been looking to Europe for decades now, saying, why don't we have the menu of family supports that they have in Europe? I think the fundamental reason is that family policy in Europe is about having babies, okay? It's about encouraging people to have children. The European countries are small countries surrounded by potential adversaries, and they're very concerned with having enough people to eventually have an army to defend themselves. Certainly France has been like this forever. And this is an uncontroversial view. Virtually everybody agrees with it. So there's consensus that we need child care assistance and other supports for families. In the US, we don't really care about fertility. We never have. We have an ocean between us and the European countries, and we have a tradition of bringing in immigrants to deal with our population problems if we don't have enough. And so what has family policy been about in the US? Well, until recently, at least, it's been about marriage. And it's just more controversial. There's not enough consensus about exactly what and how you should work with marriage. So for me, that's the answer to this riddle about why we're not doing this and why Europe has so much. Let me talk about a bit about cohabitation with you, if I can. So you correctly call cohabitation wildly various. Wildly various. It is wildly various. And that's really the problem of figuring out what to do. You know, in thinking about how we should classify cohabitation vis-a-vis marriage, it's almost like there's kind of a type 1, type 2 error problem here, thinking in terms of like experimental design. Type 1 error is treating all kind of cohabiting unions as if they were marriages. You will vastly underestimate the number of cohabitating unions that aren't marriages. You'll have too many marriages. I mean, there are many, most really cohabiting unions are not marriage. On the other hand, if you say no cohabiting unions are like marriages, you have the opposite error, which means you do not identify the marriages that are there. So what do we do? I mean, neither you nor I is satisfied with saying all cohabiting unions should be treated like marriage. Well, I'm not satisfied with saying none should be. I'm not sure about you, Marsha. You know, where do you stand in this? And how do we begin to deal with this growing problem that is now emerging in family law?
And this is one of the central challenges for family law at this point, of course, given the extraordinary rise in cohabitation. The United States isn't even a leader in cohabitation rates, and we're relatively modest in the scope of cohabitation. But there is, at this point, absolutely no agreement, as you know, among family law scholars on how to solve the cohabitation conundrum. My own solution is that you have to take it piece by piece and look at what you're regulating to determine the best possible approach. We know that cohabitational relationships fall into 6 or 7, depending on the classification scheme, different types. So we simply can't possibly assimilate cohabitation to marriage, and nobody has urged that we should. The most common assimilationist models rely on having a child in common or relationship duration. But even if you look at those two sympathetic cases, we still see an enormous amount of variation in the kinds of relationships that people bring to the table. However, if you look at specific issues, let's take childbearing. We already have both constitutional and statutory law that require child support to be identical. It doesn't matter legally whether parents are married or not. Certainly that is the right approach. It shouldn't matter whether they're cohabiting, whether they're married, or whether they're living and have never lived together. They've always lived apart. And the central goal of child support is to provide adequate support for children, and parents' relationship status is completely irrelevant. We have a similar approach that's emerged with respect to custody. In many, if not most states, custody law is supposed to be neutral with respect to the visitation and residential care rights of parents. There's actually a lot of evidence that on the ground that's not working. Professor Peg Binnick and I did a survey of non-marital families in St. Joseph County, Indiana. And all of our sample came to us through paternity records. It's a random sample of all paternity actions filed in St. Joseph County in 2008 and 2010. In more than 2/3 of those cases, fathers obtained no visitation time whatsoever with their children. There were no shared custody cases, and there were more non-parents who obtained sole custody than there were fathers. Indiana is a state that on paper gives unmarried fathers identical rights to custody and visitation as those that married fathers receive. So we have a long ways to go in some kinds of cases in bringing the law in the books into life on the law on the ground. But there are other areas where cohabitation simply doesn't lead us to try to achieve similarity, where, for example, the needs of cohabitants and married couples are quite similar. Take inheritance rights. Spouses all have inheritance rights. Cohabitants in the United States today don't. In my view, that's the correct approach. If you want to give a cohabiting partner inheritance rights, it's very easy to do so with a will. It's also very easy to get married and achieve an inheritance right. But looking across all those relational types, too many cohabitants don't really have the same kind of sharing expectations that married couples do. So as a presumption, it doesn't make sense to simply assimilate cohabitation to marriage. I think we need to take a case-by-case approach.
Well, let me push back a bit on that. The divorce law protects not only the children, but the caregiver. And that's what's missing in cohabitation laws, protection of the caregiver. Inheritance rights could give some protection to the caregiver. Okay, you can have a will, but a lot of people don't. Okay, you can get married, but increasingly people don't. And in fact, you're not a fan of marriage as itself doing much more than living together, as I understand the book. So why not enhance the position of the caregiver to give, it's usually a her, some of the protections, such as inheritance and so forth, that a married mother undergoing a divorce would do?
Because that's not the purpose of intestacy law. I think you have to look at the underlying purposes of the legal regime. The purpose of intestacy law is, and indeed many states' regime are based on survey data to fulfill the expectations of people, their default rules, and people are free to vary them by coming up with other arrangements that they choose. I'm also going to push back on the idea that divorce law is about protecting caregivers. It isn't. Child support is aimed at providing adequate financial support for children. Spousal support has nothing to do with caregiving. You can get it whether you've been a caregiver or not. Whether you've been a caregiver is one factor that might be taken into account, but we don't have a caregiver benefit for married couples any more than we do for unmarried couples. Now, you might argue that we should devise a caregiver benefit, but then it ought to be applicable to all caregivers, not just cohabitants, but to those who are married and those who have never lived together.
Well, let's consider Social Security survivor benefits. If I survive my spouse, I'm entitled to half of the amount that the spouse got if our marriage had gone for a number of years. But if I'm cohabiting and my partner dies, I don't get any of that. Why shouldn't we enhance the position of the surviving partner the way we do surviving spouses and provide them with that benefit?
In my book, I argue that we should, because the purpose of a spousal benefit for dependent children is largely to protect those children. So if we're aiming to protect children, then yes, we need to give that benefit to cohabitants, but also to parents who were never living with the wage earner. On the other hand, there's another benefit available for a surviving spouse that applies typically to older couples. The divorced spouse can get a survivor benefit if she or he's been married to the wage earner for 10 years. There, the expectation is really based on the marital sharing ethic and the idea that that couple would have shared the retirement benefit. Therefore, we're going to make it available to the survivor when the decedent can't continue sharing. Here, I think the equities are different because you don't have that same sharing expectation for cohabiting couples that you do for married couples. So once again, it's not perfect. No rule ever is. But I think the best we can do is look at the underlying purposes of the legal regime at issue.
So I wanted to follow up a bit on this conversation and also an earlier point that Andy made about the lack of consensus, because one thing we know is that not only is marriage, really drastically down over the last 30, 40 years, so that almost 50% of children are being born, and we don't even have the 2020 census results fully, but are being born outside of marriage, but also that it's very skewed by class and then with an overlay of race, right? So that marriage is increasingly almost exclusively for more affluent people who stay married longer, so the divorce rate is down. And so even putting aside the adults, for the children in these families, the rules are not really just about how we're going to regulate cohabitation, but for children, but increasingly, how are we going to try to achieve equality? One of the principles you identify in a world where equality is increasing. So childhood poverty is increasing and increasing again, disparately by race. And just to build on your earlier point, I think one of the reasons, Marsha, I'd be interested to know what you think, that we don't have consensus here because most European countries are much more homogenous. And we actually have seen a breakdown of some of these public systems, particularly in Scandinavia, with the rise of non-white, non-Christian immigrants. So I know that's a lot, but basically, I guess part of it is what is the role of race and class, and how, what role does the increasing inequality play in your analysis?
So I want to take up your last point first, because Andy mentioned it earlier. Why don't we adopt all these European supports for families? I completely agree with you, Andy, that pronatalism is part of it in Europe. It's the major reason in France. It isn't the major reason in Scandinavia, I think. Their social solidarity has been a much more important theme. So if we look across nations, we see variation in why they have developed robust family supports. Why haven't the United States? Historically, we've been very suspicious of government in all respects. It's not just family policy. We tend to rely on market private solutions. So we don't like the idea of government handouts, and thus there's been a strong tendency to view it as a handout. There's been pushback even on Social Security from conservatives in the United States, who don't view it as an important aspect of social solidarity, but as a non-market solution that we want to curtail because market solutions and private enterprise are better. And I think it's going to be tough. I completely agree with you to get around that rhetoric. On the other hand, we see increasing public support in the United States across political, religious, and class lines for robust government support for families. That's evident in opinion polls that show that child care assistance, for example, commands majority support, not just from Democrats, but also for Republicans. We see that with respect to parental and family leave. There's enormous public support for these initiatives. And eventually, we're going to see more support by state governments. It's already happening. California has its own family leave program. There are other states that are following suit. And eventually, the United States will begin to develop more programs. We're way far behind. But just as with private family law, public family law does not all emerge in the identical way at the identical time. As Cynthia mentioned, a relatively progressive state like New York did not adopt no-fault divorce until 2010. there's lots of variation in the way the family law revolution of the 1960s has played out. And there's going to be variation in the way the public family law revolution, where Europe certainly has done much better than we have, will play out. And that, of course, relates to Cynthia's second question, a major reason why I wanted to write this book. The class divide in family life, while it's a factor in Europe, is much more prominent in the United States. And it's a serious, pressing problem. We know that the way families form, live, and dissolve now plays an extraordinarily important role in determining the life prospects of children. And those at the top live very different lives than those at the bottom. College-educated women, about 2016 at least, Andy's come up with data that shows that this is shifting, and I'd like to get his take on this. But historically, college-educated women have not given birth outside of marriage. Women who don't complete high school overwhelmingly give birth in non-marital relationships. And as you move up the educational ladder, you see the pattern toward marital, far more durable relationships increase. An interesting fact, the U.S. divorce rate is now identical to the U.S. divorce rate in 1950. It's declined that much.
And most of that decline has been among the college educated.
Exactly, because those are the people who still get married. The reason why our divorce rate is so low is because marriage is much less common, and it is far more concentrated among educated, better off couples. People who were poor have always had a higher divorce rate than the general public, and the well-educated, they've also had much less satisfactory relationships. As I describe in the book, there are surveys going back to the 1930s which show that occupational status and education played an enormously important role in determining marital satisfaction. And in 1950, perhaps the heyday of relational stability and economic success for lower income families in the United States, a well-known American sociologist reported that somewhere between 50 and 60% of lower class families, as he put it, dissolved by death, divorce, desertion, or incarceration. In the grand scheme of things, not much has changed. Being on the bottom has always been worse for family life. But those pressures have accelerated today and have increased dramatically as a result of the movement to cohabitation. In the Fragile Family Studies, which is an important source of information about non-marital families, literally only about a third of children saw their parents' relationships survive for as long as 5 years. By the time those children were 9 years old, we're talking about somewhere about 15% of relationships survive. 60% of married couples had their relationships survive at this point. And Peg Brenning's in my study of non-marital families in South Bend, where these families were seeking support, the divide is even starker. The median age at non-marital separation for those families was 2 years.
It's almost as if we have two family systems.
Exactly.
A family system for the college educated and a family system for the rest. They're remarkably different. I agree with everything you said. Let me talk a little bit with you about the public law aspect of this. So given that we're in the US and we pragmatically would like some programs to pass, how do we deal with this? One way we've dealt with this is by crafting policies that appeal to those who believe that there should be a work test for support, but which also provide assistance to lots of single parents. The premier program that does this is called the Earned Income Tax Credit, which provides, as you know, a refundable credit to families in which at least one person works, or if a single parent, that person works. Marsha, you don't like the Earned Income Tax Credit at all. Okay, you say it's a third-rate program, and if it wasn't in existence, you wouldn't even have thought of it. I'm paraphrasing a bit, but you don't like it. I'm not sure it's my first choice as a family program, but it has lasted and it has expanded because it appeals to those who believe that we should only reward work, and it appeals to those who believe we should provide a lot of assistance to low-income single-parent families, because it does both. Isn't this a good program? Okay, it's not an ideal program, but isn't this the pragmatic choice that we should be making if we want to get things enacted?
The problem is it's about the only way that we're supporting low-income families at this point. And it doesn't provide much bang for the buck. If you compare it with child benefit, which European nations prefer as a primary poverty reductions strategy, it's much less effective, first of all, because the poorest of the poor families don't typically have a wage.
You have to work. So people who don't work get nothing. Right? With a child allowance, they would.
Exactly.
But for people who are working,
the deepest poverty simply is unaffected by an earned income tax credit strategy. Beyond that, the earned income tax credit still leaves families poor. It's low wage work. The United States has the highest proportion of low wage work among peer nations. It subsidizes, therefore, low wage employment. These parents are often eligible for other forms of public assistance. State public assistance benefits today disproportionately go to the working poor. And a very small proportion of the dollars spent on earned income tax credit, thus ultimately are serving the families that need this kind of support.
Without doubt, the whole
it also
family
simply
supports-
doesn't really work to promote work. The United States has actually a smaller percentage of single mothers who work than peer nations in Europe. That fact is typically overlooked.
I'm not sure that's the fault of the earned income tax credit. It certainly helps working families. If you make $20,000 a year, you can get you have a few kids, you can get $5,000 or $6,000 a year. And that's a good
And
point.
I'm not suggesting that we eliminate the earned income tax credit entirely. Most European countries and other peer nations that have adopted some form of earned income tax credit use it as an incentive to work, but not a primary poverty reduction strategy.
Let me give you
that's the approach that I think.
I just wanted to jump in for a minute to remind the audience to that people can put questions in the Q&A box, and that in just a couple of minutes we'll be taking some of those questions.
Let me give you my.
But I want to ask you a question.
Okay, well, let me ask you one more before you ask me.
I haven't had a chance to ask you any questions.
Let's give you my pitch about liberal social policy, liberal family policy people, of which I count myself as one, and where we have fallen short. You have a great discussion of all these policies in the third part of your book, and it's terrific. The whole book is great. And you talk about evidence-based policy. Now, I do evidence-based policy. Okay?
You do?
I mean, I'm an evidence guy. Okay, I like evidence, but I think that liberal social policy people have made a mistake to think all you have to do is show the evidence and the policy will be enacted. I think you have to speak to values, and you have to craft this in order to get things done, to speak to values, to talk about transforming values. Evidence is great. You and I do a lot of it. We care about it. It matters a lot. It's necessary, but not sufficient, I think, to get family policies done. That's the way I would put it.
Absolutely. And that's why before talking about evidence, I spend a lot of time talking about values in this book. Evidence is irrelevant unless you have a value. You don't know what you want to use the evidence for unless you know what you're trying to achieve. And I do think that we can, at this point, describe a set of widely shared fundamental values applicable to family life. As you noted earlier, one value that I identify, widely accepted today, is individual autonomy and equality for adult partners. A second is a strong protectionist regime for children. We expect parents today to cooperate around their children's care and to provide for them just as we always have. And that's where the new values focus of traditional family law is today located. We also, and this has been more neglected, expect legal rules, both public and private, to treat equivalent family situations in consistent ways. Finally, we today expect the state to help families. That was not always true. But as those statistics that I described just a few minutes ago suggest, that is no longer the case. Families today, it is widely accepted, can't do it on their own. The family is no longer the principal source of economic support when hard times come. Unemployment insurance, Social Security, all of these supports are today accepted, widely expected across the political board. And in the debate over hot button issues like abortion, same-sex marriage, it's very easy to forget that we actually have a lot of consensus on fundamental issues that crosses party lines and that can enable us to build some rules that build on that consensus and really help families.
So you can ask your question of Andy, and then we're starting to get some questions in from the audience.
So I want to go back to cohabitation.
Yeah.
You have charted recently a real increase in cohabitation among college-educated women. And we're also seeing market developments that suggest that the college-educated may soon become much more vulnerable than they have been. They've been the big winners in our economy until recently. Artificial intelligence may really change that. I'd like your prognostication on what we can see with respect to cohabitation and family formation in the future.
I think we may have passed the peak in which the college educated are different from the less educated. Wages for the college education were going up way more than wages for less educated people till about 2000. They haven't so much. Really, there's more of a stasis now in that. As you're saying, new developments and new technology are eating into some of the white collar jobs that college educated people did. And so we may find that the college people are more vulnerable. I found recently an increase in college-educated women having children outside of marriage. Now, it's still far less, than less-educated women. I don't want to say this is a huge trend, but it's there. And I actually think it's often among older college-educated women who don't see themselves having a child, except if they have one now outside of marriage. If we had better data, we might even see donor insemination and other factors creeping into this. But it may be now that that college-educated group is no longer as invulnerable to the kinds of changes in the economy that we've seen among the less educated over the past 3 or 4 years.
Great. Well, so a couple of questions. Oh, someone, sorry, just to be clear, Andy, someone said online that your mic is going in and out a little bit. So maybe we can just.
Well, maybe someone can help me with that.
Yeah, Liz?
Because my little green light is on and it says on. So
yeah,
that's all I can do.
Is it better now? Well, first of all, thank you for alerting us. I'll ask the first question and maybe we can hear from someone. Yes, it's better now. Okay, great. Thank you. Okay, so the question is, the original Build Back Better plan proposed had many supports for families built into it, but it never ended up being passed into law. That's a great question. If we were only going to pass one law for families in the U.S., whether or not it was one proposed in that plan or something else, what would you pick and why? Are you only allowed to pick one?
Whoa, we're only allowed to pick one.
Yeah, I know which one I'd like, and it might be the same one you'd like. I would like some kind of child allowance, okay? As we were speaking a few minutes before we started, during 2021, during the pandemic, we had for the first time in the U.S. an effective child allowance, meaning a certain amount of money that goes to families for every child they have, regardless of their circumstances. And it was called a fully refundable tax credit, but it was a child allowance. That's the greatest poverty reducing bill that could happen. Now, it's interesting to me that in the debates among the Democrats about Build Back Better, that did not come out first. What came out first is assistance to working parents, especially working parents who might have more education and have childcare issues. That trumped child poverty in a way that was surprising to me. But that's the one I would pick. It's not the one that got the greatest support in the run-up to the failed Build Back Better bill.
I'll confess that
something.
I'm torn. Absolutely. A child allowance is our best child poverty strategy, as this blue ribbon panel convened by Congress to investigate child poverty admitted. It's the only way we can really make a serious dent in child poverty. And if I had to pick one, I would probably agree, but it's divisive. And I think we might have better luck with an attention that focused on early education. One of the points I make in the book is that early education is absolutely crucial, both to children in terms of their life chances and in terms of parents' capacity to work. The United States is way behind here. Our peer nations typically make completely free school available, at least at age 3, to all children. Almost no American states do. If we were to redefine school as starting at an earlier age, there are lots of social inclusion benefits because these public school benefits would be available to all families. And we'd also have educational benefits that would give poor children the kind of leap forward they need to succeed in school later on. So I'm really torn between education and child allowance.
Here's an advantage of the child allowance. It is reaching out to conservatives. Conservatives who feel that support ought to go to parents who are staying home as well as parents who are working. Parents who are homeschooling their children rather than those who are using the state to educate them. And I think there's actually a fair amount of support among conservatives for a child allowance. Mitt Romney has proposed one.
Yeah, Mitt Romney's plan was very good.
Right. Yeah. There's disagreement about whether there should be a work requirement attached to it. So it gets back to values again. What are we going to think about that? But it does reach out because it provides the broadest base of evidence to different kinds of families, including the still not uncommon families in which a parent stays home and another one works.
I would just add, I agree with you both, probably a slight thumb on the scale towards the child allowance. But first of all, more questions. Feel free to ask more questions. I would just say that perhaps maybe from the more cynical perspective, that I wasn't surprised by the Democrats because I think, first of all, the child allowance was only proposed by Mitt Romney first, and then Biden after. Or in the midst of the pandemic, when middle-class, sometimes nuclear, more white families, more acceptable to policymakers of both kinds, were really struggling with childcare and other things. And so the low-income families who've been sort of invisible in many ways, or at least not powerful enough to many policymakers, I think that's really what drove it at that time, even though that's been an issue, obviously, for decades for other families. And I think even the working requirement is really, like you said, it's about values, but I think it's also a little bit about, bias, right? Like we all know,
stereotypes of the welfare
stereotypes of wealth, which are, highly racialized, not accurate. People with young children, just they can't work, and especially the kind of job, or they can't work full time without family leave, without enough money to afford, transportation in the kinds of retail and other kinds of jobs, service jobs that low-income people or people with less education can get are incredibly not family-friendly. So, again, I just think it's not really necessarily about a work requirement or about stereotypes of certain kinds of people without really looking at what kind of jobs are available and what would be realistic for them.
I'd be happy with either of these.
Well, it's a very difficult question to just pick one, certainly. But I think I agree with something you said earlier, Marsha, which is that there's substantial progress on family leave now, on parents being able to take leave from their jobs when they have a new child. And here again, that does cost a lot of value.
Absolutely.
It's not just for working parents it's not just for two-income families. One-income families can still do that. Fathers can still do that. And so the policies that have the broadest reach politically are the ones where we're making the greatest progress.
And that's where I think both child allowances and the kind of educational reforms that I talked about are ultimately going to have a lot of appeal because they apply not just to the poor, but to middle-class families who also need these supports. They don't need them as much, But just as Social Security is now very hard to dump politically, once families have supports that are useful to the large bulk of families, it's going to be a lot harder to get rid of them. So these benefits that provide what are generally described as social inclusion benefits as well as economic benefits, I think are the way we're going to get to where we need to go. We're not going to do it easily, though.
So while we're waiting for more questions, I wanted to ask you what you thought, both of you, about sort of universal. I mean, that's sort of partly what you're referring to, which is something that, again, Americans have been very resistant to, universal benefits, which are pretty standard in a lot of European countries, like not means tested. Is that sort of what you're referring to, Marsha?
Yes,
Yeah.
exactly.
There's a push and there's a pull. Universal benefits that go to people that you might not think deserve them lead people to be opposed to them. You talked about race and class. One must always talk about racial and class divisions in the U.S. About some people's views that only certain people deserve that. African Americans were cut out of the Social Security Act in 1935 as a compromise to Southern senators who wouldn't have approved it beforehand. Social Security applied except to agricultural and household workers when it first started, and that was most of African Americans, at least in the South. So clearly that's the case. On the other hand, if you extend benefits to what's left of the breadwinner homemaker family, okay, if you extend benefits to say the 25% of families where there's two parents and one is staying at home, you appeal to a group that sees much of what the liberals do as not benefiting them at all. And so it does provide some reach for universal benefits. How you package them makes a difference. And one must always guard against the tendency to think some people are more deserving than others. But there's something about universal benefits that may reach across the aisle.
I mean, I think it's no accident that Mitt Romney came up with a good child benefit package. There is room for across the aisle approach here, even in the highly divisive political world we now live in.
Yep. So we have a question. I guess if you speak loudly, well, no.
Why don't you repeat it?
Yes, I will repeat it. Oh, for getting a mic. Thank you.
So just a comment following up on that. One thing that I have found interesting is that states that have adopted pre-K programs have not been just blue states. Kentucky was one of the first states to adopt universal pre-K, and it's definitely across political lines. But I want to, the question I want to ask you is changing the subject a little bit from what you've been focusing on. And you mentioned, Marsha, at the beginning of your remarks, that one way in which families have an increasing burden today is that family caretakers are caring for older adults more than they were in the past, when the families are smaller, nuclear families are smaller, but that as individuals live longer lives, the burden of family care has become much more onerous. And I think it's sort of interesting to note that this conversation about family law and family policy and private and public family law has really been about care of children. And I think that is what we mostly focus on in both private and public family law. But it's predicted that in another generation or so, there will be more Americans over age 65 than under 18. And so the interest of older adults has been pretty much ignored both in family formation, private law, and in family policy or support for family caregivers. And I wonder if you have thoughts about that now, both of you.
That's a great question. And one immediate thought is that one of the United States is way behind our peer nations in most respects, but one way in which we're actually ahead of the game is that while most European nations have parental leave programs, even the federal family medical leave statute applies broadly to individuals who leave work to care not just for children, but for partners, other family members, and even themselves. And that's true of California's new initiative, which involves paid family leave. So I think paid family leave is a key piece, and one which can really play a role in assisting these family caregivers who are dealing with older adults. A focus on children is not inappropriate, however, because we know that children who were separated from parents early in life are much less likely to provide care for those parents when those parents age. So the two are linked. And in a world of ever expanding numbers of separated families, where particularly men have seldom lived with their children, we're going to have a lot of men without the kind of supports they need as they age. They won't have a spouse. They won't have adult children to care for them. Who is going to do it? It's really going to be a crisis, and we are not at this point prepared in any way to deal with it. At this point, 95% of unpaid care to the elderly is done by family members. And there are lots of families that are caught in the middle. They have children and they have parents for whom care is needed at both ends. It's a tremendous social problem. I wish we had a solution.
So, Professor Scott, your question reorients us toward caring for older population. There's lots to think about there. Did you know that about 1 out of every 3 divorces now is among people aged 50 and over? That's because my generation, okay, is probably the highest generation of cumulative divorce in the history of this country, including what will happen to people younger than me, okay? We were the people who started to get divorced in the 70s and 80s, and you know what? We're still getting divorced. And so there's a rising number of divorces among older people. And while they don't have young children, they do have estates, they have wills, they have issues of who is going to support whom. Anecdotally, we're hearing that a number of older people who are getting together are not marrying, so that they're not bound by new laws, or they're having prenuptial agreements. I'm sure there's a growing number of family lawyers who are dealing with these kinds of issues as the older population becomes, as you said, even greater. So far, we're doing okay because the U.S. doesn't have quite the number of older people relative to younger people as other countries, let's say a place like Japan, but we're getting there. You know, in the next 10 or 20 years, we're going to see a lot of interest involving how do older people go about doing their families, of course, how they care for one another, and how their children care for them is important. We know, for example, that stepchildren, on average, care for their elderly step-parents less than biological children care for their elderly biological parents. But how do parents as actors, not just as people to be cared for, but people who are living active lives, how do they deal with family and family law? I think it's going to be a new horizon, probably already is.
Oh, it definitely already is. And the fastest growing relational type among these older Americans is so-called living apart together, a committed relationship in which the parties are not cohabiting and have chosen not to marry.
Which, of course, seemed scandalous when it first emerged among the youth, but now among older couples is being very pragmatic in the way that they're doing it.
Yeah, absolutely. So we have lots of problems, and as yet, we don't have the kind of solutions we need. Certainly, there's going to be a need for a major public investment unless we can provide the kind of supports that enable families to provide informal care. We often don't really think about the economic value of that care. But even taking childcare, there was an Australian survey done a few years ago that attempted to quantify what it was worth. And what it came down to was 25% of the gross domestic product of Australia had it been added in. That's childcare alone. So we're talking about extraordinary, valuable care that if we had to pay for it, would consume an enormous amount of public resources.
Right, and one of the main goals, whether it's elders or children in U.S. policy, as you point out, Marsha, but is the privatization of dependency, or taking care of those who cannot work or be self-sufficient financially. But again, just like with who's getting married and who's not, that does skew as well, right? That's gendered. Starting to change, but certainly still with women performing far more, even the vast majority of, for instance, mothers who are working outside the home, they're still performing a lot more care in the home. So given that, what is the way we think politically to get that, huge number, a huge amount of unpaid labor forward, given that, again, a lot of people more legislators and judges and so on are less likely to be the people doing that unpaid labor themselves.
You're the sociologist here. Do you have a question?
How do we get people to do that? How do we get people to
How do you get people to see the invisible labor, especially when, it is very gendered, to be taken for granted, I guess, to some degree?
I think it is more visible than in the past. I think it was invisible in the 1950s. Very much invisible. It's the case now that I think that labor in the home is being seen more. It's not necessarily valued economically more. But it is the case that, again, across the spectrum, people are valuing this kind of work and seeing that it should be supported. And that's a big change. I think that we are seeing that not only families with two earners should be supported, but families with one earner and one non-earner are be supported. We still are a long way from valuing caring labor as much as we should. We undervalue caring labor in this country. We always have. We pay it less. The statistics are legion. One that I like is that until recently, at least, child care workers were paid less than gas station attendants in terms of hourly pay. So we pay them less. We value it less. There's a movement, a care work movement to try to transform it. I support it. It would be great if it had more traction.
Thank you. I think we have another question.
Yes. Hi. My question brings us back to the title of the book, not the tying the knot part, but the family justice part. So it's called Family Life, Family Law, and Family Justice. And I'm really curious what the term family justice means to you. I'm saying this especially because I feel like we're increasingly putting that word justice at the end of concepts that are important to implicate things that are broader than just what can happen in a courtroom, something bigger. And so potentially some of the support, the support the state could be giving financially or otherwise. But the word justice means so many different things to so many people. So I'm really curious what you think about when you use that term.
It's a great question. Fundamentally, as we all know, law is not necessarily just. It may not be fair. It may not work perfectly. It may not achieve the kind of equitable results that we hope to achieve. So family justice connotes family laws that do achieve those goals, that provide fair, equitable, economically feasible, and workable solutions to the problems that families actually face. So my goal here is to, looking at how families live, move to a family law that actually provides the kind of equity and justice that we would like to achieve for our families.
And Marsha, I think that's the most distinctive aspect of your book, the family justice part, which I see coming up most in the last third of the book when you talk about public laws and what we ought to do. That's what makes this book most different from other books that I've read. Clearly, there's lots of good thinking in the first 2/3. There are lots of issues that we talked about. But to connect it up with larger issues of justice and public law is something that I've not seen before. And I think it gets a discussion started about how to think about it and how to do it. And it's not easy to think about it because different people have different conceptions about exactly what family justice might mean. And you put forth yours, and I heartily agree with the vast majority of it. But it's a contribution to get us thinking about that.
Yes, and I certainly don't pretend to have solved all the problems. I do think family justice isn't just public family law, that we can reform private family law in ways to make it more just too, and I take up some of those. I also think we can look at innovative solutions to help families, and that might be classified as family justice. One of the chapters of the book, for example, talks about how we might help families to be more durable. We know there are programs that have helped improve family functioning. The nurse-family partnership is perhaps the best known, which has been so successful in improving parental care that the federal government now funds it. Endless numbers of research projects demonstrated its utility. The federal government has come up with a few demonstration projects to try to improve adult family functioning. And thus far, the results have been pretty mixed, not very successful. We can think of other ways in which we could improve family functioning. One I talked about is long-term reversible contraceptives. Now, that sounds like an odd family policy program, but we know that one of the primary sources of family instability is unintentional pregnancy. It's particularly common in non-marital relationships. It's particularly common in teenage births. And the United States has the highest level of unintended and teenage births among our peer nations. We have opportunities to reduce unintended birth through much more effective public policies that support effective contribution, the kind of effective contribution that young women actually want.
So let me talk with you for a minute about long active
LARCs.
contraception.
Yeah, LARCs.
Yes.
Let's just call them LARCs.
Sorry, LARCs. What they are is a hormonal stick that would you put underneath the surface of your skin, or an IUD that would prevent pregnancy. And they're highly effective because they do not require any thought at the time of sexual activity. As preliminary studies suggest that they can really reduce early pregnancy, early age pregnancy. And if you could just get many women to wait a few more years before the first child, that would really be quite significant. So you would think, who could possibly be against LARCs? Well, the answer is there are a number of advocacy groups for low-income women, and especially minority low-income women, who say this as limiting fertility among the poor. So even this technologically savvy new arrangement, which you might think on an evidence-based basis would be something that we could easily put forward, is running into some difficulty.
That's actually really dovetails with something I wanted to ask, which is about going back to the suspicion of government that you mentioned earlier, and a suspicion and sort of the notion of privacy, which might be, I think, rationally particularly suspicious among certain groups. And how do we overcome that among certain groups who've been marginalized? How do we overcome that given the history in this country of interfering with the reproduction and family formation and family retention among minority groups and others? How can we overcome that when there are things like LARCs that would actually be really helpful?
I think it takes time, and I think your evidence is important. The example that comes to mind is, we mentioned earlier that New York was slow to adopt no-fault divorce. Who opposed it? Women's advocates, on the theory that women were disadvantaged by divorce and that the fault requirement therefore benefited women by giving them a bargaining chip. What that ignored is that the vast majority of divorce plaintiffs are women. And there's research that suggests that this is not just courtesy, but that women are more prone to be dissatisfied with an unhappy marriage and want out. It took time for women's advocates to come to the realization that that was correct, that fault divorce did not benefit women in any respect. I think it's going to take time for the groups that you're describing to realize that LARCs benefit low-income women, Black, brown, and white, and that they are not forced on women, but instead in effective contraceptive medical centers offered as one choice among many. All the evidence we have suggests that when LARCs are offered as a package of contraceptive alternatives, and their utility is explained, people want them. And not only do they want them, but they have a very high retention rate. In most surveys, more than 80% of women who choose a LAR continue to use it at least a year later. And we know that they work. The state of Colorado perhaps gives us the best example here. It literally succeeded in raising the age at first birth by more than a year. That's an enormous success. And to reduce the number of unintended teen births by something like 60%. I can't think of any public policy initiative that has achieved that result that startling over such a brief time period and in an extraordinarily cost-effective way. All the reports suggest that the state would save hundreds of millions of dollars in welfare costs as a result of this initiative. So there's one example where I think we can, with the right evidence, the right publicity, truly build coalitions around measures that will prove extremely popular among users.
Marsha, let me ask you a bit of an unfair last question. Where is the field of family law now? How would you say it's positioned relative to the kinds of changes we've seen and are seeing?
Well, I think the reason I wrote this book is I think we haven't gotten there yet. Now, that's not entirely the fault of family law scholars like Cynthia and myself. All family law scholars hope to gain the ear of a legislature. We want legislators to do what we tell them to do, but most of the time they don't ask us. And legislatures, as you know, are creatures of public opinion. They're creatures of lobbying campaigns by interest groups. It's not so easy in the mix of that cacophony to get good family law ideas to get the hearing that they need and deserve. We academics need to build better coalitions with the right interest groups so that we can produce there in the State House the kind of legal solutions that we think about here, talking among ourselves, writing about and talking about in the classroom.
Yeah, they don't ask us either. Legislators do not ask social scientists very much either. I don't think family law can do it by itself, nor can social science. I think family law to affect change must build on evidence provided in part by social science, by assessing the lay of the land as it's done. And when that's done well, I think that both fields can work together. Certainly that's been my experience with family law. I mean, I've always had a very good but little distant relationship with family law, where I've come to see it as a partner, really, which depends on us doing good work in social science, just as we may depend on you to actually get this in front of some of the people in the law community who need to know about it.
Right. I just wanted to add one last factor in, which is sort of the lived experience of families, which you also write a lot about. So how do we balance values, empirics, and research, and then the lived experience or voices of people, which part of it comes through research, but I mean, not so much necessarily in the aggregate.
Well, here I think building coalitions with advocacy groups for different segments of the population may be really important because that helps us to get those stories out there. Some of the most effective scholarship that I think has helped family law scholars understand, particularly how poor families operate, are the ethnographic studies that have actually looked qualitatively at the lived lives of families on the ground and provided highly detailed, finely grained accounts. Those stories really can make a difference in building support. There's a good reason why every journalist begins with a story. It grabs the attention. It helps you to identify with the plight of people in this category. So I think we need those stories. And I think that perhaps we as family law scholars need to build our ties with the kind of organizations and their core constituents to put those stories before legislators, back them up with the kind of evidence that Andy and his colleagues are producing and try a little harder.
Well, that seems like a great place to end with the thanks, Marsha and Andy, for a great conversation, and especially Marsha for a wonderful book. And now we have an action plan going forward to be able to help family law and policy improve to help actual families.
And thanks to both of you and to those of you who have been listening.